Well, thank you very much for joining me in this video. Got a phone call from one of my agents this past week. They said they were off to list a property, and they said they discovered that one of the former owners of the property had passed away in the property. And their question was, is that something I need to disclose? And this whole issue of disclosure, we've covered it before, but it's really important, I think, we revisit it because there's so many aspects to it. If you disclose something that you maybe don't have to, you could be stigmatizing the property. If you don't disclose something that you should, you could be opening both yourself and your seller up for liability. So we need to take a look at a number of different aspects. First of all, we want to take a look at latent defects. Then we want to take a look at patent defects. And then we got to take a look at gray areas, things that are partway between a latent defect and a patent defect. And then there's the principle of active concealment, how that applies, and then finally, material facts. So let's take a look at them. First of all, let's starting with a latent defect. A latent defect, remember, is a hidden defect. It means it's something that's not readily discernible. You could even have a home inspector and they would probably not be aware of it. And yet, especially if it goes to the structure, the foundation, the safety of the property, it must be disclosed. And so whether the homeowner knows about it and tells the realtor, or whether they don't tell the realtor and the realtor needs to then ask some pertinent questions because there's an obligation on the part of the seller to disclose it. If they don't disclose it, after closing, the buyer can come back on the seller and there's going to be some liability involved. Now, I say they should disclose it. The principle goes on if known. Well, obviously they can't disclose what they don't know, but it goes on not just if it's known, but if it should reasonably be something that they're aware of. So the foundation is cracked badly, it's parged on the outside, it's drywalled on the inside. This work was done after the fact. It's going to be difficult for them to say, well, we didn't know. So there's an obligation there, and it's an obligation on our part when we take a listing to ask a number of questions to find out if there are any latent defects. Then we get into the realm of patent defects, and patent defects comes under the heading of caveat emptor, or buyer beware. That's why you need to very carefully examine the property. That's why it's a really good idea to have a home inspector go through the property so there aren't any hidden surprises. And you know, if you're representing the seller, you walk through the living room and the floor squeaks, a hardwood floor should be braced underneath. That isn't something you need to disclose. It might be a defect, but it's a latent defect. It's a patent defect, and a buyer can readily discover it. Let's suppose that there's a crack in the plaster. Well, take a look around, you'll see a crack in the plaster. As long as it isn't an indication of a foundation problem that is a serious structural problem, that's not something that needs to be disclosed. That is a patent defect. Buyer beware. But then there's this issue of active concealment. It's a patent defect, but the seller is going out of their way to hide it so the buyer won't discover it. And they're taking the position, well, it was there, you had a chance to look around, you should have discovered it. There was a situation where there was a large counter, the house was being sold, and there was a potholder laying on the counter. After the fact, the buyer discovered that the potholder was strategically placed on the counter to cover a large burn on the counter. That's active concealment. They're going out of their way to hide it. Had another situation where after the homeowner moved everything out, they moved out an area rug in the living room, and there was a large faded area outside of where the rug was, where the sun hit the floor and the rug protected it. And so you could see the difference in discoloration. Well, that wasn't active concealment. In other words, they didn't put the rug there to cause the problem. The rug caused the problem over time. So that was something that wouldn't come under active concealment, but you need to be careful of that. You need to ask some questions again. And then we get into this whole issue of gray areas. This is where, well, it's hard to really categorically know whether you should disclose it or not. It falls somewhere between a patent defect and a latent defect. Gave the example to start with about somebody dying in the house. What about if somebody had committed suicide in the house? That moves it up a level, and maybe there's a larger number of people that would want to know about that before they entered into a contract. As I said, on the one hand, you don't want to stigmatize a property. On the other hand, you don't want to hide issues that will become pertinent. Houses hit by lightning and a lot of damage. It was totally restored. Does that something that should be disclosed, or is that something that would stigmatize the house and shouldn't be disclosed? And there's no hard and fast rules to gray areas, but I would use this as a rule of thumb. Anything that a neighbor is going to come tearing over and disclose 5 minutes after the buyer moves in, it's probably a good idea to let them know ahead of time. You can tell the agent representing the buyer, and they can choose what they're going to say to their buyer, but do it in conjunction with the seller. Make sure the seller's comfortable about it, because you are stigmatizing. And as I say, it's a gray area. And then it leads us into the last thing I want to talk about for a minute, and that's material fact. Material fact is kind of a funny thing. It's anything, any fact about the property that would influence somebody in their decision to buy or sell, and at what price. The trouble is, it's subjective. If I'm buying a property and somebody died at home of natural causes 2 years ago, I don't care, but there's other people who would never consider buying that property if somebody had passed away in the property. And so it's a material fact, it's subjective. So how do I know what I disclose as a material fact and what I don't? Well, the thing you need to bear in mind is that the obligation to disclose a material fact is an obligation that you disclose to your client. So you don't need to disclose it on a listing to everybody else's client. It's up to that agent to ask questions. For example, if somebody passing away in the house is an important issue to the buyer, ask the buyer that, and then ask the listing agent to find out. So it's a material fact to the person making the decision, and the agent for that particular person needs to find out the answer to that. So you don't need to stigmatize the property by disclosing material facts, but you need to have the answer in case you're inquired. I hope that all makes sense. It can be a little bit convoluted. It's a kind of a juggling act between stigmatizing a property and full disclosure, so you don't leave your seller open to some kind of litigation. Hope that makes sense. Thank you very much for joining me. Talk to you again next week.